All rise. Please be seated.
Good morning and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Good morning, Your Honor. This is case KAC BC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
Thank you, Madam Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor, Madam Prosecutor, Mr. Prosecutor.
Good morning, Your Honor. For the Specialist Prosecutor's Office this morning, in attendance are Mr. Jack Smith, who's the Specialist Prosecutor. Directly behind me is Mr. Sebastian van Hooijdonk, who is a Case Management Assistant with our office. To my right is Claire Lawson, the head of our legal office. At the end of this row is Mr. Alan Teeger, a senior prosecutor, and I am David Harbach, a prosecutor with our office. Good morning, Your Honor.
Thank you, Mr. Prosecutor. Now I turn to the defense, and like I did for the last status conference, I will call the lead counsel for each accused as they are reflected in the case name, starting with counsel for Mr. Thaci, then counsel for Mr. Veseli, then counsel for Mr. Selimi, then counsel for Mr. Krasniqi. May counsel introduce themselves and their team, starting with Mr. Hooper, please. Mr. Hooper, I think your microphone is mute.
Yes, good morning, Your Honour, and may I also say good morning to Mr. Thaci. I'm representing Mr. Thaci today together with Mr. Palaska. Thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
Good morning, Your Honour. This is Ben Emerson on behalf of Kadri Veseli for today's hearing.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, good morning. For Mr. Selimi, myself, David Young, and today I'm assisted by my co-counsel, Mr. Jeffrey Roberts. Thank you.
Thank you, Mr. Young. Ms. Allegendra.
Your Honour, good morning. Venkateshwari Allegendra together with Mr. Aidan Ellis for Mr. Krasniqi.
Thank you, Ms. Allegendra. And for the record, I note that Mr. Thaci, Mr. Veseli, Mr. Selimi, and Mr. Krasniqi are not physically present in the courtroom, but attend this hearing via video conference. Now I turn to the registry, please.
Your Honour, Ralph Roach, Head of Judicial Services Division.
Thank you, Mr. Roche. And for the record, I'm Nicholas Guillou, pretrial judge for this case. Before we proceed with our agenda today, I would like to remind the parties that should they wish to take the floor to raise a specific issue or to respond to anything that has been said, they shall stand up if they're in the courtroom or raise their hand if they're attending the hearing via video conference. And finally, should anyone attending the status conference via video conference experience any technical difficulties, please inform the court officer and myself immediately by waving your hand. If the connection with any of the remote participants fails, we will do our best to reconnect immediately. If the issue cannot be resolved immediately, I may have to adjourn the hearing for a couple of minutes to ensure that the line is reconnected. Now let me move to the recent procedural history of the case. On 8 December 2020, I scheduled the second status conference. I asked the parties to provide written submissions, if they so wished, on the following topics: disclosure, the status of the SPO investigations, the status of defense investigations, the date for the third status conference, and any other matter they wished to raise. The SPO did not submit any observations, and 2 defense teams submitted their observations on Tuesday, 15 December. I thank Mr. Hooper and Mr. Emerson for their written submissions. Before we carry on with today's agenda, I also wish to note that yesterday evening, I issued a decision on certain procedural matters related to the review of detention and the deadline for filing of preliminary motions. The purpose of our hearing today is to review the status of the case and to organize exchanges between the parties to ensure expeditious preparation for trial. In particular, I wish to discuss, first, the disclosure of evidentiary material, notably if the parties are facing any difficulties and whether any further progress has been made, inter partes, in reaching agreement on the level of categorization of disclosed material pursuant to Rule 109C of the rules, and the timing of submission of the related chart. Second, whether an estimate date of completion can be provided for the SPO's outstanding investigations, and when the SPO will be able to file its pretrial brief and related material in light of the calendar set out in my framework decision on disclosure. Third, whether the defense can provide information on the status of its investigations, on its intention to make request regarding unique investigative opportunity, and if it intends to give a notice of an alibi or grounds for excluding responsibility. And fourth, the date of the third status conference in this case, and any issues the party may wish to raise. I will invite the parties to present their views in a concise fashion about each item, and I will ask the parties for their submissions in turn. I remind the parties to give prior notice should any submission require the disclosure of confidential information, so we can go into private or closed session. Now I invite the parties to follow the agenda set out for this status conference. I first would like to hear from the prosecution on the topics in the agenda related to disclosure of evidentiary material and the Rule 109C charts. The floor is to the prosecution. Ms. Lawson.
Good morning, Your Honour. With regard to the disclosure process, the SPO has now already disclosed 1,309 potentially exculpatory items pursuant to Rule 103. In addition, we have disclosed indictment supporting materials pursuant to Rule 102(1)(a in both English and Albanian, and have also disclosed statements obtained from the accused, again pursuant to Rule 102(1)(a, and again in both English and Albanian. The materials already disclosed pursuant to Rule 102(1)(a comprise 1,764 items. In light of certain technical issues in generating those disclosure packages, which I will mention in a moment, we're conducting a detailed cross-check to ensure that process is complete. The SPO is committed to continuing to meet the rigorous disclosure timeline which has been set out. Looking to the immediate future, and in line with our commitment to rolling disclosure, we anticipate disclosing a second package of potentially exculpatory items shortly after the judicial recess. With respect to difficulties encountered, there have been certain ongoing technical problems with the legal workflow. By way of example, the package of potentially exculpatory material was disclosed by the SPO at 15:24 on the 10th of December and was available to the Chamber and the defence teams in legal workflow from that time. However, due to a technical issue, no notification of the disclosure package was sent to recipients until one was manually generated the following day after having made multiple unsuccessful attempts to resolve the technical problem. Equally, the SPO experienced significant delays of up to 15 hours in the upload of material to legal workflow. Problems were encountered regardless of the size of the disclosure package in question. And these type of issues are outside of the SPO's control, and in fact, due to the nature of the legal workflow system, some of them are beyond the direct ability of registry staff to remedy. We are actively engaging with registry and with relevant external contractors to identify and address the problems going forward. And we take this opportunity to sincerely thank relevant registry staff from CMU and from IT for their availability and assistance, including late into the night on a number of days. The Thaci defense also identified 2 additional points relating to metadata in their filing, and I will take this opportunity to address those points. The first was in relation to record type metadata, and the second was in relation to originator metadata. With regard to record type, the SPO has been careful to try and provide meaningful document descriptions. So, for example, where an item is an interview or a video or a photograph, the description should state that fact. It is easy to sort the metadata according to file type, also, for example, an MP4 file as opposed to a PDF one, which again is a straightforward way of identifying from the existing metadata which are audio or video materials. Therefore, the metadata already available is easily searchable and sortable for these types of records. The time-consuming reworking and redisclosure required to complete the record type metadata field would be largely duplicative with the information which is already available to the defense. In respect of the originator or chain of custody, again, no order is required. The originator field specifies exactly where the SITF SPO obtained the item in question. The Thaci defense provided 2 examples of originator metadata which they appear to consider inadequate. One is where the phrase SPO witness interview is used. That description is used where the evidentiary item in question is the transcript of an SPO interview. So the item and origin is exactly what the metadata says it is. The second example highlighted was a particular library that was identified as the origin of an item. In that case, an SITF SPO member went and identified and photographed the item at the library. So again, the origin is exactly as has been provided in the metadata. There is no missing chain, there is no hidden intermediary. The originator field contains the individual or the organization from which the item in question was obtained. Of course, if there are particular metadata items or descriptions that appear unclear, we would be happy to see if we can provide any further explanation. And we submit that this would be most efficiently done on an inter partes basis so that we can have the opportunity to review the relevant entries. Would you like me, Your Honour, would you like me to address Rule 109C now as well, or will we do that? Okay. It was probably apparent to Your Honour from the Thaci defence filing that there has not been further progress or agreement between the parties on the issue of Rule 109C. The Thaci defence submissions repeat the prior position outlined by the Salimi defence. So essentially, there has been no change. The impasse that has been reached is a very simple one, though. It is exactly the clash between the ideal and the practicable. The SPO has been clear in prior submissions on this issue as to the unpracticable burden that the defence request would create and the consequent very significant impact on the disclosure timeline. The Thaci defence have now attempted to frame this as a matter of statutory interpretation and of entitlement. However, the relevant provision is clear. It is a requirement to do what is practicable. Moreover, the basic division into the 4 categories identified in Rule 109 is something which Your Honour has already accepted to be compatible with that rule in, for example, the Mustafa case. Basically put, it is a choice between receiving the documents in a timely fashion or of receiving additional elaborate categorizations of very questionable utility. Because again, this categorization is nothing but a supplementary tool to the many other navigational aids which the SPO will be providing pursuant to the rules. Thank you.
Thank you, Ms. Lawson. Mr. Hooper, you have the floor. Mr. Hooper, microphone, please.
It will come as little surprise to Your Honour to know that, in fact, my realm perhaps isn't entirely one of disclosure and the various form and formats that it takes, and I rely very much on Ms. Menegon for that. And so I'll take up what my friend has just suggested, that there be further inter-parties discussions in respect of the matter that she raised. But having said that, Your Honour is doubtless familiar with the disclosure, the format of the schedule that's been accompanying the disclosure packages, whether that's been disclosure package 8 in respect of exculpatory matters, or the subsequent 9 to 12 for incriminating material. And when one looks at the column-headed categories in respect of that, it is, as we submitted in our written submissions to you, wholly inadequate. You may as well not have anything in that column at all, given the lack of pointer that the information there provides anyone looking at it. After all, what is the objective of having that category there at all? It's to be of assistance, perhaps clearly to those to whom the material is being disclosed, and being disclosed by the party whose material it is, who's had the material often for very many years, and is surely in a position with very little effort to provide the increased material, the increased descriptions. So, for example, where it describes the crime as underlying crimes, is that adequate? Which crimes? When it relates to the alleged conduct of the accused, we're back on that sort of job lot argument that the defense raised in objection right at the outset of this case. Which accused? When it relates to contextual elements, why doesn't it specify whether that's even a crime against humanity or a war crime? So when my friend says that we're pointing to the rules and to a statutory interpretation that somehow, in fact, implies too much request for detail, it surely merely conforms with, in fact, the wording of Rule 109C. So I merely repeat paragraph 13 of our submissions, essentially, in respect of that. In respect of disclosure, we do need, not only in respect of the categories, further detail, but also the type of item that it is, and that doesn't appear in the legal workflow. I don't know what further tools my friend's talking about that are going to assist the defence. This is the point of first reference when material is served on us. And we look to legal workflow for the specificity that we'd naturally expect. In terms of originator, chain of custody surely involves more than where a document was found. It's also literally the chain of custody of that document. And we'd need further detail in respect of that. As I say, I don't know to what extent further discussions with the prosecution are going to bear fruit. We're willing to enter into those discussions. Thank you.
Thank you, Mr. Hooper. Now I turn to Mr. Emerson, please.
I think Your Honour will be aware from the outset that on behalf of Mr. Vasili, the defence takes a simple position, which is that it is the prosecution's obligation to meet the disclosure requirements of the applicable legislation, and it is no part of the function of the defence to assist them in doing so. I have not, therefore, taken part in the discussions towards the formulation of the table of identification, nor do I think it's practical at this stage for the defence to be asked to make informed submissions about the adequacy of disclosure. We have, as you've heard, received something in excess of 3,000 documents in a very short space of time. The only realistic response to that is to say, of course, each and every one of those documents will require the most meticulous individual analysis and examination by the defence. No responsible defence counsel would delegate an analysis of relevance to the prosecution. Indeed, I find it very difficult to understand how that type of process is likely to take matters very much further. Having said that, once the analysis has been performed, when and if it becomes apparent that there are gaps in the disclosure or in the continuity, we reserve the right to make submissions on the implications of that. But in real terms, in the real world, the defence, of course, is just beginning at the very foothills of the process of identifying the categories of material disclosed by the SPO, and obviously for that reason is not yet in a position to make informed submissions on the adequacy of the procedures being adopted. I am not going to allow myself to be driven into the position of making piecemeal criticisms of an exercise that the prosecution is conducting when we're not in a position to have analysed the material. This is the prosecution's obligation. We sit back and we wait to see how they perform it. So those are my submissions at this stage. In other words, it is premature to be asking the defence to respond with complaints about the adequacy of disclosure. They may be very much more detailed and deep than the ones that are capable of being made at this stage. And in particular, you'll note also that the defence of Mr. Vasili filed no submission on the extraordinarily extensive redaction applications that were made very recently. By the same token, it is impossible for us at this stage to make informed submissions on the relevance of those redactions or the underlying evidence. And I am not going to be driven into making ill-informed submissions at a premature point in the process. Thank you.
Thank you, Mr. Emerson. Now I turn to Mr. Young, please.
Yes, Your Honour, thank you very much. Your Honour asks the defence, are there any difficulties in relation to disclosure? And so I'm going to deal with this right now, because we would submit respectfully that there are substantial difficulties in relation to the approach that the prosecution have adopted. Your Honour may remember at the last status conference, when I addressed Your Honour, on the importance of disclosure being meaningful and comprehensible, given the fact that the right to fair and proper disclosure is synonymous with the right to a fair trial. And this is why the question that Your Honour has posed with respect is a very good one, and it's so important. And on the last occasion, I believe I warned against the danger of disclosure falling into, I think I described it as a legal black hole of a computer, and sought to impress you on the need to properly categorise information. Unfortunately, the prosecution have fallen foul at the very first hurdle in terms of disclosure, because the purported categorisation is of no use at all. The descriptions given in the disclosures with respect such as evidence to be presented or alleged conduct of the accused are essentially meaningless. And clearly they do not fulfill, we would submit, the obligations upon the SPO under Rule 109. For example, under Rule 109A, as Your Honour knows, a party should be able to search electronically for relevant materials. And I ask rhetorically, how are the defence able to search electronically when one's given its evidence to be presented? If you look at the wording of 109C, Your Honour will be aware that the parties, and the SPO in particular, at this stage, as far as practicable, shall, so it's mandatory, categorise the information in accordance with the charges in the indictment, with specific reference to the underlying crimes, contextual elements of the offences, alleged conduct, and so on. The important point is, it's clear we would submit from the reading of 109C, this isn't about setting out the categories. They're there in 109. The point of 109, as Your Honour can see, is to categorise the information. We know what the categories are. And Your Honour knows that in the Salimi filing of the 27th of November 2020, we made specific submissions to Your Honour on Rule 109C, explaining the type of information which should be included in the disclosures. And that's at page 2, paragraph 2 of our filing. So we would submit, Your Honour, that disclosure needs to be made in an organised fashion. It needs to be comprehensible, and it needs to be referable to the indictment allegations. So, for example, basic information such as type of crime, location, mode of liability. This is basic information. And with respect, the prosecution must know their case. They've been here investigating for many, many years. They have the relevant information. The SPO appear to have taken a deliberate policy, or with respect, strategic decision, not to fulfill their disclosure obligations. And if this is permitted, it will have a seriously prejudicial and detrimental impact on defence preparations and investigations, and it will exponentially increase the workload on the defence. My learned friend for the prosecution sought to pray and aid the position in the Mustafa case. As I understand it, in the Mustafa case, in distinction to this case, the defence counsel there agreed with the SPO position. So, with great respect, that's very easily distinguishable. So, these are the submissions I make. Thank you.
Thank you, Mr. Young. Now I turn to Ms. Alagendra.
Honor, thank you. May I defer to counsel, Mr. Ellis, to address the difficulties that we've had with the disclosure, as well as the categorization of the disclosure, Your Honor.
Absolutely. Mr. Ellis, please.
Your Honor, I'm grateful. Your Honor, whilst we appreciate the opportunity to update the Chamber this morning, we also have received between the 11th and the 15th of December a very large amount of material. We're reading it, we're analysing it, and our investigations will start from that point when we have had the chance to properly read it and analyse all of it. We're not in a position today to provide any more meaningful update than that. Safe to say that one thing we can address is the categorisation pursuant to Rule 109C. The reality is that there haven't been any further progresses between the parties. As the matter comes before Your Honour this morning, we continue to support what was originally the Salimi defence proposal in relation to categorisation and the written submissions made on that by the Thaci defence in writing before this hearing. 2 brief points. we would submit first that the wording of Rule 109C is clear and requires the disclosing party to categorize information in accordance with the charges in the indictment. And simply applying a label such as underlying crimes does nothing to categorize the information in accordance with the charges in the indictment. In a case as large as this one, what is required is surely some link to the specific charge and the location. And the second point, of course, Your Honour, is that must follow from the purpose of Rule 109C, which must be to assist the receiving party in categorising and understanding the information that is provided. And again, a label such as underlying crimes is so broad and being applied to so many documents that it is really of very little assistance or practical utility at all. Your Honour, those are our submissions.
Thank you very much. Ms. Lawson, do you want to take the floor to respond to what has been said by the defense?
Thank you, Your Honour. We clearly dispute the Salimi defence characterisation that the SPO has not fulfilled its disclosure obligations. I have outlined in detail already the significant steps taken and the SPO position on the points that have been raised. The specific link that's being requested in respect of categorisation will be provided in the form of the chart in respect of the Rule 102.1b material. Thank you.
Thank you, Ms. Lawson. Well, I take note that inter partes discussions will continue as regard the first item that has been discussed by Mr. Hooper. I also take note that there is still a disagreement between the parties on their interpretation of Rule 109C. I invite the parties to continue to work on this matter, and I will see if a ruling is necessary on this issue in the following weeks. Unless any party has anything to add on this topic, no. Then I will move to the second topic on the agenda, and I will turn back to the prosecutor to ask about the status of its ongoing investigations. In particular, can you give an estimated date of completion of your outstanding investigations? And when, approximatively, do you think you will be in a position to file your pretrial brief and related material? Mr. Tiger.
Thank you, Your Honor. I'll address that if I might. With respect to the question of whether an estimated date of completion can be provided for investigations, I want to underscore that our investigative efforts will be governed by our statutory scheme, by the rules of evidence and procedure, which provide that after a certain stage of the proceedings, the use of witnesses, witness statements, and documents require judicial authorization. Now, this framework ensures that the expeditious preparation for trial is not disrupted, while at the same time, consistent with the other ad hoc tribunals and the ICC, that investigations may continue. And there are many reasons in the interest of justice why investigations are permitted to continue, ranging from the appearance of a previously apprehensive witness who now finds the courage to provide information, to the discovery of a previously hidden repository of important materials, to attacks on witness credibility during trial of a dubious nature that need to be looked into. Those are just a few of the many, many examples that justifiably result in, and indeed I would say mandate, continuing investigation of a sort. Now, I am aware of concerns that have arisen from circumstances where lengthy post-indictment investigations were viewed as resulting in a delay in commencing trial. That is clearly not the case here. Here it is the prosecution seeking the expeditious arrival of a date upon which the results of further investigation will require judicial authorization and thereby limit and restrict the scope of prospective investigations. So, in short, while we are unable to put a date and would not put a date to the projected end of investigation, it will not adversely affect the objective of an expeditious and fair trial, and indeed, in our submission, would enhance it. I don't know if the court wishes me to proceed to the second part of the inquiry immediately. With respect then to our estimate of when we will be able to file our pretrial brief and the related Rule 95 submissions, in this circumstance, based on our current projection of the commencement of a trial date in September, which we've explained to the court, we would be prepared to file the pretrial brief and the related materials in early July, that is 2 to 3 months before the commencement of trial. Now, I hasten to add that the proviso that we view the framework of this institution and as holistic and integrated, and I've just explained how the prosecution's investigative efforts are related to the progress of an imminence of trial. Those factors should not be detached. So if that projected trial date were to shift, we would maintain our position of being able to submit those materials 2 to 3 months before trial, but they should not be artificially separated such that that submission was made and then a long, long period of time transpired before trial commenced. Thank you, Your Honor.
Thank you. I will now give the floor to the defense on this topic of the SPO investigations. Mr. Hooper.
I noticed Mr. Teague referred to 2 or 3 months before commencement of trial. I hope he doesn't know something that we don't know. But I've no other observations to make in respect of their investigations. Thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
Your Honor, I wouldn't take issue with the basic formulation that Mr. Teague has put forward in relation to the need for the prosecution and indeed the defense to be able to continue investigations in certain circumstances as the process and indeed the trial itself proceeds. Of course, there will be issues that rise ex improviso unexpectedly that need to be addressed. What we would suggest is that there needs to be, and I'm going to use the word loosely, a guillotine imposed at a reasonably approximate point in time, which is the date beyond which, as Mr. Teague points out, the judicial approval is necessarily required, and that the presumption is that the prosecution no longer is entitled to adduce evidence at will. And I don't think there's any dispute between us that there needs to be such a guillotine date. The question is, when should it be? And that leads me on to the second point. And it's one in which I do depart very firmly from Mr. Teague and the position that the prosecution has adopted now on more than one occasion, namely that there is somehow an inextricable link between the progress of the prosecution's investigation and disclosure obligations and the proximity of the trial date. I just want to analyze that briefly, if I may, for a moment, because it's come up now on several occasions. What Mr. Teager has just said to you is that the date on which the prosecution should be required to nail its colours to the mast in a pretrial brief to state what its case really is should be pegged to the date of trial and to be 3 months in advance. Now, the underlying assumption, and I think the only possible inference from this, is that the prosecution takes the view that it would be adverse to its interests if the defense had more than 3 months to prepare the case once the prosecution have fully identified the parameters of the evidence and charges and the way in which they want to relate the one to the other. And that is a cause for very serious concern. Last time, counsel for the prosecution suggested that disclosure dates should be brought backwards or forwards, and indeed pretrial brief dates brought backwards or forwards because of the likely realistic trial date. And we've heard it just now from Mr. Teager once again. He is saying we could be ready to file the pre-trial brief in June or July, but only if there's going to be a trial in September. If the trial, in fact, is not until the following June or July, even though we would be ready in June or July of this year, we want to hold it back. We want to disadvantage the defense preparation by ensuring that it has no more than 3 months to prepare for trial. Now, I'm sorry to have to say this because I thought I'd flagged up the impropriety involved in that position at the last hearing, and I'm surprised to see a responsible prosecutor continuing to make that as though it were somehow a respectable position for the prosecution to take. He says, we wouldn't want you to uncouple the date of trial from the date on which we must file our pre-trial brief or close the disclosure without further judicial authorization. But in fact, it is a shocking submission to be making because there can only be one reason for it, which is to restrict the ability of the defense to fairly and properly test and answer the evidence. In other words, to impose a limit. Now, if the rules or the law intended to say a fair trial requires the defense to have short opportunity to defend the case, then they would say so. The fact that they don't is self-evidently consistent with the fundamental rules of natural justice, which is that the length of time it takes to investigate and prepare a case of this complexity is determined by the volume and complexity of the material, not by some arbitrary deadline that the prosecutor wants to impose to make life difficult for the defense. And just to put that in context, the suggestion here, serious suggestion here, is that the prosecution's guillotine, in the sense that the date on which it must finally identify its case, because as we know, the relevance process that they're currently undergoing, we've seen that in relation to the first point of your agenda, is not a means of providing the defense with substantive information. And in any event, as I said earlier, it's no substitute for the fact that the defense needs to determine relevance for itself. But there is a moment in the process when the prosecution has to say and is required to say, this is our case. This is the case you have to meet. And Mr. Teager has told us now very clearly the prosecution can do that and therefore should be made to do that by June or July of 2021. But to suggest that that's only the appropriate approach if there's a trial 3 months later is to imply that the period of time the defense should have between the clarification of the prosecution case and the start of the trial should be 3 months. I want to put that in context. Attached to our application for provisional release, you will find a very detailed piece of academic research into the functioning of the international criminal tribunals, both the ad hoc tribunals and the ICC, in terms of the scope and scale of their investigations and the length of time it normally takes between first appearance in the tribunals and the start of the trial. It'll be sufficient for me to tell you that the statistics show that at the ICTY, the average length of time between first appearance and at the start of the trial was 3.6 years. Now, that's an extremely long time. And it's absolutely right, of course, that efforts should be made by international tribunals to improve on that. And the ICC has improved on it. It's got the delay down to 2.3 years. But this is not about administrative delay. This is about how long it takes to conduct a proper investigation into cases of this gravity and complexity. And most specifically, leaving averages aside, because of course they don't allow for the very different nature of particular cases, there are two cases which are as closely parallel to this one as it is possible to get. The Limai and others trial at the ICTY, and then the Haredini trial at the ICTY. Both trials involved allegations of joint criminal enterprise against members of the Kosovo Liberation Army, in particular leaders, zone commanders in particular areas. Unlike this case, they did not cover the whole of Kosovo or the 2-year period of this indictment period, or indeed parts of northern Albania, nor were there 4 defendants. In each case, there were 3 defendants. The time period was limited. In the Haredini case, it was 6 months. The geographical area was strictly limited. In Haredini, it was an area around the Dukagjina region, the Dukagjina operational zone, a relatively small part of Western Kosovo, and in the Limai case, another comparatively confined area. So in both cases, you had confined area, a much shorter period of time, and 3 defendants rather than 4, and the time that was considered necessary for the preparation and presentation of the defense investigation between first appearance and the beginning of the trial was 18 months in the case of Limai and 2 years in the case of Haredini. It is self-evident that those are basic minimums, and that in this case, where there are more than 100 murders on the indictment, each of which has to be individually investigated forensically with witnesses and so forth, together with a vastly larger number of alleged unlawful detentions, all of which have to be investigated. The notion that the trial could begin 3 months after the prosecution has prepared its trial brief is a joke. It's not just a joke, though. It's a revelation of an attempt by the prosecution, I regret to say, to railroad this into an unjust, unfair trial. Of course, it goes without saying that we will not allow that to occur. And I can tell you now, this is not a matter of negotiation or bargaining. This is not a matter of indulgence to the defense. It's a basic minimum legal right to have a fair trial. And a fair trial is one which, as the statute, the Constitution, and the European Convention make clear, that begins after adequate time and facilities for the investigation and preparation of the defense. That, as I say, it's not a matter of bargaining or of sucking in sea. It's not an estimation. It's a basic minimum right. And given the accumulated experience of international criminal justice, the prosecution cannot be serious in this suggestion. And therefore, one has to ask oneself why it is being made. We would suggest today is the day to sever that connection between the prosecution's duty to disclose its case and file its pre-trial brief and the start date of the trial. Indeed, we would suggest that you should firmly reject the position taken by Mr. Tiga, that you should uncouple consciously, deliberately, and in the interests of justice, the 2 sets of obligations, that you should take up the prosecution on their commitment to serve their pre-trial brief by the earliest date that they are able to, which they have told us is June or July of next year, and then allow the defense to make appropriate submissions based on the nature, scope, and extent of the case and the investigations that were required as to when a realistic start date should occur. But the notion that the prosecution should allow a sliding scale to be put in place, which enables them to delay their disclosure obligations in their pre-trial brief in order to try to achieve a trial by ambush, which is what is going on here, I know, sir, that as the pre-trial judge, Your Honour, you will stand firm and ensure that justice is not allowed to be railroaded in that way. Those are my submissions.
Thank you very much, Mr. Emerson. Mr. Young, please.
Your Honour, I adopt entirely the submissions of Mr. Emerson. I have nothing to add.
Thank you, Mr. Young. Ms. Alejandra or Mr. Ellis?
Your Honour, we also adopt the submissions of Mr. Emerson.
Thank you, Ms. Alejandra. Mr. Tiger, do you wish to respond? Briefly, please.
Thank you, Your Honor. Only to say briefly that Mr. Emerson's submissions are predicated upon his view of the length of time required to move to trial, which is not usefully informed in our submission by comparative dates to a lengthy ICTY experience. We set out in our written submissions the reasons why we depart from that view, and I won't elaborate on those. I'll simply say that we reject the characterization that our position in the earlier submissions reflects any attempt to subvert a fair trial. Quite the contrary. We consider that investigations and the results of investigations are very much in the interest of justice. They're built into the framework of our rules of evidence and procedure, and the earlier submissions stand as a way to balance the approaches that lead ultimately to the fairest possible trial. Thank you, Your Honor.
Thank you, Mr. Tiger. I will definitely not set a date to start the trial today, but I've heard the parties on this important exchange, and this will certainly be addressed in the next status conferences because it's a very important matter indeed. Unless any other party has anything to say on this matter, I will then turn to the next point of the agenda, which relates to the defense investigations. I would like to turn to the defense first now. I am mindful that it might be premature at this stage for the defense to be in a position to have a clear vision on its timeline, but I would nevertheless be interested to know, if defense wants already, first, whether based on the SPO's estimates on the ongoing disclosure of evidence process, scheduled to continue until July 2021, the defense can provide more information on the status of its investigations. Then whether the defense can provide information on any intention to make requests concerning unique investigative opportunities, pursuant to Rule 99. And then whether the defense can provide information on any intention at this stage to give notice of an alibi or grounds for excluding responsibility. Mr. Hooper, please.
Yeah, well, thank you, Honor. I'm very grateful that Your Honor's just used the words that you thought this query was perhaps premature, because indeed it is. We haven't begun to think of initiating investigations or addressing that, and I hope Your Honor will respect the reasons why that is, because it is too early. We've just received just the initial disclosures relating to this supporting material. We're still downloading that, let alone examining it and assuming a viewpoint on the basis of it. In a way, your question raises the issues that Mr. Emerson has eloquently addressed just a few minutes ago. When Your Honor first asked us, or we indicated on behalf of the Thaci defense, that we thought that the beginnings, shall I put it like that, of a realistic trial date was in the summer of 2022. That wasn't, as it were, put down as a counterbalance to the prosecution's ludicrous statement of 6 months, with a view perhaps to Your Honour settling in the middle and therefore thinking that perhaps 12 months would be appropriate. The 18 months was in fact quite clearly the very minimum that we foresaw at that stage was going to be necessary to begin really to see that we would have the necessary team and mechanics and investigators on the ground in order to be prepared for a trial that could conceivably start in the summer of 2022. I must say, for our part, we very much echo what Mr. Emerson said this morning. And listening to Mr. Teager sitting here in my room in London, I have to almost pinch myself. Is he really saying this? Is he really saying this trial could take place in that way? And in the same breath, talk about fair trial? It is inconceivable. And I must say, I've come to this institution with my mind open. But I must say the conduct of the prosecution hitherto has been disappointing, to put it mildly. And I'll say no more about it. Your Honour, we haven't begun to put our investigatory team together. It's going to take a while. It's going to take a good 18 months plus to begin to investigate this case. That's the reality of it. Your Honour's indicated that Your Honour's not going to set a trial date today. Well, I'm very grateful for that. And from what Your Honour said, in terms of it will be the subject of discussion of future status conference, I feel confident that our submissions are not falling on stony ground as far as Your Honour's concerned, and that this is a matter that's going to take many months to resolve. I thank Your Honour.
Thank you, Mr. Hooper. Mr. Emerson, please.
We have taken some preliminary steps towards the process of establishing an investigatory mechanism. Obviously, the only document we have at the moment which is remotely intelligible in terms of enabling our investigation team to start devising a strategy is the very recently disclosed lesser redacted version of the indictment. That is literally the high watermark of the case that we have, but it begins to give some indication of the number of incidents and to some degree, the geography of some of them, as well as the names of certain identifiable individuals, although of course not the names of a significant number. Based on that lesser redacted version of the indictment, it is, we say, quite apparent, as I said earlier, that the defence will need to carry out very extensive investigations into each of the individual instances of enforced disappearance, acts of ill treatment, and murder alleged. Can I just say that compared to other cases, this is rather an unusual one. Because in certainly every other case I've been familiar with, the ICTY or the ICC, or indeed the other regional tribunals, there has been a central allegation against the accused going beyond a mere attempt to associate together a vast number of individual crimes, in none of which any of them were involved. This indictment is unprecedented in the sense that it is made up simply of a patchwork of a vast number of individual incidents, which so far as we can tell are connected only to the extent that it is alleged that the people involved in them claimed at one stage or another allegiance to the emerging guerrilla group that called itself the Kosovo Liberation Army. And so it's a case where, unlike in many instances where the crime base itself is not usually a huge area of contest, each one of these requires an individual investigation, and each one is necessarily going to require a critical examination before one can stand back, as the prosecution invites the trial chamber to do, and view the implications of the total of the sum of the parts. And so I say that, I make that clear at this stage, because Mr. Tiga is right to say you can't compare it necessarily to all of the other trials in the other tribunals, but actually the comparison, if anything, is one which points to a more thorough and detailed investigation in this case, in which it will be, of course, vital for the defence to cooperate with one another as far as possible, to avoid the duplication of effort, and expense, and delay that would otherwise bedevil a case of this unusual nature. That said, we have identified with a senior international expert from the national security field as supervisor of the defence investigation for Mr. Vasili, so that there will be an individual able to guarantee the integrity in every respect of the defence investigations. And we have identified and appointed the senior investigator in Kosovo, who is a qualified lawyer admitted to practice in Kosovo and is part of the defence team. We expect that we will be recruiting up to 6 individual investigators on the ground. In the Haredini case, we used an entire team of London Metropolitan Police officers, or former police officers, to conduct the investigation. On this occasion, we proposed one national security international supervising a team of qualified lawyers. And so that essentially is the scope. Obviously, they need the opportunity to analyze the information that's a blizzard of documents that are being produced by the prosecution at this moment, in order to be in a position to start working out a scope. A scope needs a narrative to start with, and a narrative then needs priorities to be identified. And then you can start working out how you go about conducting individual witness interviews and so forth. If Mr. Tiga and his team think that we're going to start this trial without having conducted an investigation at least as thorough as the prosecution's investigation, then I'm afraid he is sadly mistaken. And I don't think any of the defence teams in this case would participate in something that was being put forward as a charade of a trial, because anything short of a proper investigation of these allegations would be a charade of a trial. So the reality is that once the SPO investigation is, once the SPO case is properly known, then it will be possible to begin devising in detail the scope and scheme for the defence investigation. We would like to think that once we've got through the judicial recess, we will have a body of material from the prosecution that we can begin to assimilate, analyse, and draw a narrative from, using the de-redacted indictment as the basis for that. But let me reiterate what I said earlier on, which is that there are 2 phases to the defence investigation. Phase 1, whilst the prosecution investigation remains ongoing without any judicial scrutiny at all, lasts up until June, according to the timetable Mr. Tiga has envisaged. And in June or July, the guillotine comes down. And after that, the prosecution must seek judicial authorisation to introduce any new evidence. And also, at that time, they are in a position to and should be required to file their pre-trial brief. That's the moment at which the defence can say, right, we now know what the prosecution case is and where it begins and where it ends, subject to a judicial extension. And from that point onwards, I can tell you, Your Honour, from experience, the minimum time required will be 12 months. I mean, that is, I actually don't believe that we will get the trial started in real terms in July 2022. I think it will probably be the end of 2022 or the beginning of 2023, when you take account of two things. One is that the time frame for investigation is inevitably going to be set back by the fact that COVID vaccinations are not likely to be widely available until at least Easter of next year. And that does pose very real problems in terms of availability of witnesses and conduct face-to-face investigations. But the other factor is, I can tell you now that there will be defence applications to you on a jurisdiction, defence challenge to jurisdiction, and quite probably interim and interlocutory appeals if necessary on other issues. So the minimum time frame that's being put forward, which is 6 months while the prosecution has unrestricted right to investigate, and 12 months once that right has come to an end and the pre-trial brief has been served, that is a realistic starting point given the circumstances. It also happens to come to 18 months, which is the minimum time frame that we have been suggesting from the outset. But I would entirely endorse Mr. Hooper's, the marker that Mr. Hooper has laid down, which is that is a basic minimum. And anything over and above that or rather the risk of going beyond and above that is an ever-present one, having regard to two things. One is the likelihood of interim or possibility of interim appeals. The second, the COVID issue, but also the very point that Mr. Teager makes. And there's Mr. Teager saying to you, it's absolutely vital in the interests of justice that the prosecution should be able to continue investigating even past the guillotine, albeit with judicial supervision. Well, the same is true for the defence. And so 18 months, absolute bare minimum, that if that date is set, it's an optimistic date. We will, of course, keep the pre-trial chamber fully informed of the progress of our investigations. But we're serious about doing this and doing it professionally. We're ready to start in the new year. So those are our submissions on defence investigation.
Thank you very much, Mr. Emerson. Mr. Young, please.
Your Honour, we support and adopt the submissions of Mr. Hooper and Mr. Emerson. Thank you.
Thank you, Mr. Young. Ms. Allegendra.
Your Honour, we too adopt the submissions of Mr. Hooper and Mr. Emerson. It's a very realistic position that the defence is in, Your Honour, and 18 months we feel would be the minimum that we would require for investigations. That is all, Your Honour.
Thank you very much, Ms. Allegendra. Mr. Teager, do you wish to respond?
No, Your Honour, thank you.
Thank you, Mr. Teager. Obviously, we're not going to decide today on the length of the investigations, but I take note of everything that has been said today. And as I said before, we will certainly have further discussions on this matter in the next status conferences. Talking about the next status conferences, I would now like to ask the parties on their views for a suitable date for the next status conference. And I remind everyone that in this regard, should counsel or the accused wish to participate via video conference, written notice must be provided 24 hours in advance of the relevant hearing so that the registry has the time to make the appropriate accommodations. And such notice should include the written consent of the accused. Mr. Prosecutor.
Thank you, Your Honour. Our position is that the next status conference should take place in January, which is consistent with our general view of the need for and value of frequent and regular status conferences at which the court can both ascertain and guide progress of the case and the implementation of steps necessary by all parties toward trial. Now, obviously, this is true for all parties, but I would underscore that it may be particularly important in circumstances where such steps or even the answers to questions about when such steps may be taken are deferred on the basis that they're premature according to the parties' own generous timetable about when trial should commence. Under those circumstances, we submit that the court would not wish to let long periods of time go by, but rather set regular and frequent times to monitor progress and impose deadlines and prevent the estimations of a trial in the long-distance future from becoming a self-fulfilling prophecy by virtue of steps not implemented when they could be.
Thank you, Mr. Tiger. Mr. Hooper, please.
Well, so far we seem to have been having status conferences at a monthly interval, and I'd have no objection and perhaps recommend that we have a status conference towards the end of January in a month's time. Thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
May I echo Mr. Tiger's observation that close trial and pre-trial management is an important part of this process in order that we can take a realistic appraisal of how long a trial takes. But the implication underlying his submission that this is somehow a time frame pulled from the air, or that the defense are seeking to drag their heels, is offensive and wrong. And I would respectfully ask him to withdraw that suggestion. We agree that a monthly status conference is a sound way of proceeding, and we are confident that we will be able to demonstrate to Your Honour in detail why the time estimate we have been given is the realistic one. And at some point in this process, the prosecution will stop, give up making these absurd suggestions about trial in the middle of next year. But obviously they haven't quite got to that point yet. The timetable for the next status conference, I would like to suggest on or about the 14th of January. As I've noted in our submissions for today's status conference, on behalf of Mr. Vasili, an application for provisional release, a reasoned application at the request of the prosecution, has been filed, and we would ask you to set a timetable for the prosecution to respond by the 31st of December, for the defence to reply by the 11th of January, and for the next status conference to occur on the 14th of January, at which we would invite you to hear oral submissions in support of the application for provisional release.
Thank you, Mr. Emerson. I look forward to reading your application. Just to inform you that I already addressed these matters in a decision that I issued last evening, especially on the timeline for the requests. But I will definitely look into your request, the one that has been filed. Mr. Young.
Your Honour, thank you. I would submit perhaps in a month's time, Your Honour.
Thank you, Mr. Young. Ms. Alagendra.
We to agree on a month's time, Your Honour.
Thank you very much. A status conference will be scheduled in due course, but I can already tell you that I share your views that regular status conferences, probably around, one every month, is definitely something that I intend for the following months in this case, to monitor the expeditiousness of the parties. And what I really want to avoid is that we waste time, is that time is wasted because there is no coordination. That is something that I want to avoid. The parties need to have the time to do their investigation. We need a fair trial for sure, but I definitely want to be as expeditious as possible in the case, and the pretrial judge will be available for the parties to rule on any matter should it be necessary to ensure this expeditiousness. Just want to note for the record that we've had, and we're still having, a little problem with the transcript, which is apparently stopped for the moment, the real-time transcript. This will not prevent us to benefit from the transcript at the end of the hearing. I see the court officer is mentioning something. Okay, so apparently it's just for me that the transcript is not working and it works for the others. So apparently it's been fixed for the others. So it may be only some of the computers, so we'll try to fix that. But I can inform you that it will have no impact on the availability of the transcript at the end of this hearing. At this point, I would like to ask the parties whether they have any other issues they would like to raise. Starting with the prosecution.
No, Your Honor, thank you very much.
Thank you, Mr. Tiger. Mr. Hooper, please.
Yes, there's three matters essentially. Can I pass to the second matter? This relates, Your Honour, to, and we received yesterday, Your Honour's decision, or I saw yesterday Your Honour's decision in respect of extending the time period within which preliminary motions relating to jurisdiction or challenges to the indictment will need to be served. There will be challenges in respect of both those matters, I anticipate, on behalf of Mr. Thaci. At the moment, Your Honour's extended that, and we're grateful for that, to the, I think the 10th, is it, of...
10th of February.
The 10th of February. And Your Honour, it was drawn to my attention, and can I share this with Your Honour and my learned friends? The position here might in fact be affected by Rule 97.2. Now, Your Honour, 97.2 may need to be, in this context, seen in conjunction with Your Honour's order or in relation to protective measures, which effectively defers the disclosure of some matters in the course of that decision. So we're not going to get all the matters because some of it's been put on hold while various further decisions are made in respect of that material. And our Rule 97.2 reads that as far as the accused is concerned, he may file preliminary motions in writing. I'm looking now at 97.2, and such motions shall be in writing and shall be brought within 30 days from the disclosure of all material and statements referred. So all material and statements. If that reading is correct, then and if the prosecution are not going to produce matters until the 15th of January, as I understand is the date established in respect of some matters, then that would give us 30 days from that date. In other words, we'd win, as it were, another 5 days. So, Your Honour, that's the situation. I draw Your Honour's attention to it. And I don't know if I can put it in this way. If Your Honour could reflect on that and come to a decision as to whether you agree with that interpretation or not. If you do agree, then we get another 5 days in which to lodge those particular matters. The final matter, Your Honour, it comes to this. Applications for interim release. Yesterday, or rather in the early hours of this morning, I received the prosecution's response and their F-149 filing. And in respect of that, the prosecution response, as Your Honour may know, isn't a short one. It's 21 pages of argument, accompanied by over 200 pages of supporting material, which I haven't yet managed to access or read. What I'm asking for is that normally a reply from the defence at this stage would be a reply that would be submitted within 5 days. But I ask Your Honour, in fact, to vary that. The reasons I ask Your Honour to vary that is that, of course, this is a very significant matter. We've had a substantial filing, much more than we'd anticipated, may I say, from the prosecution on this matter. And it relates also to new matters that require a degree of examination, indeed investigation, on our part. We're also, of course, in receipt of Your Honour's decision in relation to our requests to have an oral hearing in respect of interim release. And Your Honour's denied that. May I say that it will come as little surprise to Your Honour that that's come as a disappointment and perhaps a matter of regret for us. Not only because perhaps on balance we perhaps thought or conjectured that Your Honour would in fact grant us an oral hearing based on our own experience and our own jurisdiction on these matters, but also our experience of principles of orality in other international courts. So it did come as at least a regret. But it means that effectively matters that we would have wanted to have brought before the court in an oral hearing are now going to have to be contained in order to advance our previous arguments. They're not additional arguments, they're matters in support of our existing contentions that interim release should be granted. And we need more time really to get those matters together. Your Honour will, goodness me, be well aware of the limitations of COVID and what's that has caused and is causing all of us, but particularly the defence, because the defence at this time, the defence at this stage are entering something of a bottleneck of activity, as Your Honour knows, because we're not only just receiving all the supporting material within in our submission in adequate description on the part of the prosecution, etc., etc. We're not only having to deal with that, we're also having to, being at the early stages of a case, the foothills, as Mr. Emerson has described it, we, all of us, are busy constructing our teams and liaising within those teams. We all have to now consider the position of complex preliminary motions, which there will be, and attend to that. And my own intention had been to go to The Hague for next Monday and Tuesday in order to have face-to-face discussions with Mr. Thaci. That can't happen because of the COVID restrictions. As Your Honour knows, you can go to a hotel now in The Hague, but you can't be fed. And this put a certain restriction on choices. But not just that, it's quite apparent that the new restrictions, both in the Netherlands and here in London, have been introduced because of the extraordinarily ascending mortality rates caused by this dreadful disease. So we're having to be very, very cautious. So there's a number of obvious factors that have come together here. I see that I think it's the Veseli case because of the particular position that they're in respect of interim release, that I think they have a sort of return date in terms of the final defense filing of, I think, about the 7th of January. That takes us over the Christmas period and the slight hiccup of the new year. And in those circumstances, I'd ask Your Honour to extend to us the opportunity to fashion our reply and its supporting materials in the fullest way possible, and to submit that at about the same time. In other words, just into the new year. That's my application in respect of that. Thank you, Honour.
Thank you very much, Mr. Hooper. Do I understand you correctly? You wish, in fact, to have a timeline similar to the one that is foreseen for the application on behalf of Mr. Veseli, correct?
Yes, indeed. I latch myself onto that, though I appreciate we're in a slightly different position because we filed earlier. But Your Honour has, as it were, would perhaps, to some extent, want to see the arguments gather together, even though I know Your Honour will be looking very subjectively at each case quite separately. Thank you.
Thank you, Mr. Hooper. Does it mean that you also agree to waive the right for Mr. Thaci to have detention reviewed in the timeline of 2 months because you need this time to prepare your response? Sorry, microphone, please, Mr. Hooper.
Oh, I'm sorry, I turned off. I'd say yes to that, but I have to confess I haven't been able to take instructions of Mr. Thaci on this issue. But judging by my conversations with him previously, I do not think that would be pose a difficulty. I don't know how I can lay eyes further than that at the moment. He's listening to us. I don't know if I can reach out to Mr. Thaci. That's not Mr. Thaci, by the way, that's come up on the screen, but if I could relate to Mr. Thaci. But I don't know if Mr. Thaci in any event would want to just discuss this in this way. Can I say to Your Honour that the answer to that is yes, but I will talk to Mr. Thaci one way or another immediately after the status conference. And if I'm in any way amiss or wrong about what I believe to be my position and his position, I will come straight back to the court and let Your Honour know.
Thank you, Mr. Hooper. It's exactly what I was going to suggest. So
there
that's
we are.
perfect.
Great minds, you see.
Noted. Mr. Emerson, please. Do you have anything to add?
Nothing to add, thank you.
Mr. Young?
Yes, very briefly. Your Honour, obviously, unless the prosecution are not opposing the interim release application made by Mr. Salimi, I understand that the prosecution are due to file possibly their response, if they are responding today, to our application for interim release. All I say is, if that is the course and they are opposing and they do respond, then I would be grateful if Your Honour would give the Salimi team a similar extension to that of Mr. Thaci, if Your Honour is minded to grant Mr. Thaci's team further time to respond. Thank you.
And Mr. Young, like I asked for Mr. Hooper, this would involve waiving the right of Mr. Salimi to have the detention reviewed according to the 2 months regular timeline. Can we agree that you have an agreement in theory, and after consulting with your client today, you will get back to me if it's not the case?
Yes, I'll do that as soon as possible. Thank you.
Thank you, Mr. Young. Ms. Alexandra, do you have anything to add?
We too are likely to ask for time to reply, Your Honour, just as the other teams have, to the interim release application. upon hearing from the prosecution.
Thank you, Mr. Legendra. Under the same conditions as I just mentioned?
Yes, Your Honor.
Thank you, Mr. Legendra. And Mr. Hooper, I took note of the two other matters that you mentioned. Just for the first one, just want to indicate that confidential filing shall not be discussed in public session, so I cannot address the matter here. It will be dealt with in writing, but I definitely took note of the point you mentioned. And I've also asked the court officer to redact the read reference in the transcript, but I will definitely take note of everything you said in future written rulings. And I also took note of what you asked for the future preliminary motions in terms of timeline as well, and it will be addressed. Unless any party has anything to add, I see Ms. Lawson. Do you want to add anything? Ms. Lawson.
Thank you, Your Honour. On the first matter raised by Mr. Thaci, I won't say anything further other than, as you noted, it's under litigation. On the preliminary motions, we would not see any basis for an extension in relation to Rule 97.2. It's very clear the type of issues that preliminary motions are intended to address. They're intended to address the form of the indictment, jurisdictional challenges, and potential severance. The very limited material that has been put to a deferred ruling is unlikely to impact that in any way. With respect to the extension requests for replies to the preliminary motion, to the interim release motions, the SPO is strongly opposed to those requests. We have submitted our responses in respect of Mr. Thaci in good time yesterday, within the standard deadline, within the standard word count. We will be doing likewise today for Mr. Salimi and Mr. Krasniqi. All parties were on notice of the importance of briefing fully in their initial filings, bearing in mind the limited scope for authorised replies as well, which may only address new issues arising, and therefore we oppose those requests. Thank you.
Thank you, Ms. Lawson. Does anybody want to add anything? Mr. Hooper.
Well, merely to say, or re-say, that the prosecution response included new matters that have been raised, and those matters need investigation.
Thank you, Mr. Hooper. I don't see anybody asking the floor. No, so this concludes today's hearing. I thank the parties and the registry for their attendance. I also thank the interpreters, stenographers, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned. Thank you.
All rise.